Ladies and gentlemen, dear colleagues, welcome to the webinar, Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism. My name is Dušan Popović. I'm professor at the University of Belgrade, Faculty of Law. At the very beginning, I would like to give you a few information about this webinar. So let me start with saying that this webinar is organized within the project which is led by the Ferenc Mádl Institute of Comparative Law in Budapest, Hungary. The title of this project is the Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism, and this is just one of the project activities. There will be other webinars, conferences, papers, and a book published as a result of this project. I would like to inform you that the head of the research group is Dr. Marcin Wielec, who is the head of department of the Cardinal Wyszynski University in Warsaw, and he is the head of the Institute of Justice of Warsaw. I'm the member of the Central European Professors Network, and this network is coordinated by the Ferenc Mádl Institute of Comparative Law in Budapest. I would like to inform you that this webinar is being recorded and will be uploaded to the Ferenc Mádl Institute of Comparative Law YouTube channel. So, of course, you can and you are expected to participate. So if you wish to ask a question, just please use the chat box. So I kindly ask you to switch off your cameras and microphones. If you have any question, you can simply write it in the chat box, which I will check from time to time. So this is the introductory webinar. I will give another one in, let's say, 6 months from now. So this introductory webinar will cover some basic aspects of the interaction between the digital platforms and the freedom of expression on the other hand. So to start with some introductory remarks, I would like to explain in what sense I'm going to use some terms. So in this project, we are actually referring to social networks, and they are actually defined quite broadly. The other term we could also use is the social media platforms. So I would say that there are some three main characteristics of social networks. And the first one being that the social networks are actually, as you are very well aware of, Web 2.0 based applications. So this shift to Web 2.0 is described as a shift from user as consumer to user as participants. And the apps are designed in a way to enable users to create, to interact, to share the content online. The second common characteristics of social networks is that the user-generated content is the essential component of the networks. Of course, it is not the exclusive component. This notion of user-generated content, which we are using in this webinar and in general in this project, is not limited only to text or to photo or to video. It could also be a simple like on a social network. And the third characteristic is that these networks connect user-specific profiles with those of other individuals or other groups. So these profiles are actually the pillars of every social network. So bearing in mind these three characteristics, it is clear that we are referring to a typical social network such as Facebook or Twitter. But we are also referring in this webinar to video sharing portals such as YouTube, for example. To give some theoretical background as an introduction to this topic, I would like to emphasize that the freedom of speech allows ordinary people to participate in the spread of ideas. So it is clearly an important element of democratic culture, in the sense that not only the cultural elite or the political elite can participate, but also any other member of the public. And this freedom of speech is, of course, interactive, because this exposure to someone else's ideas clearly influences everyone and in a way reshapes us. And this freedom of speech can also be defined as being appropriative, in the sense that everyone actually relies on some existing cultural background, draws some ideas from that background, modifies these ideas, criticizes the ideas. And speaking of this theoretical background, theoretical foundation of the freedom of speech, there are different theories. We are not going to enter into these details, but there is a line of thought saying that actually the recognition of truth is a prerequisite of social development. There are some others saying that actually the freedom of speech is being seen as an instrument of democratic self-government, or those that claim that the freedom of speech is a value in itself. And what is more relevant to us is that these are not just theories, they are actually reflected in case law. And when you actually analyze some of the cases, especially those which are quite notable and known today, you can actually find the traces, the reflection of these theories in case law. So, for instance, in U.S. law, in a landmark decision, in a case, the New York Times versus Sullivan, the U.S. Supreme Court adopted this decision restricting the ability of public officials to sue for defamation. So specifically, the court held that if a plaintiff in a defamation lawsuit is a public official or person running for public office, not only must he or she prove the normal elements of defamation, but also it has to prove that the statement was made with actual malice, meaning that the defendant either knew the statement was false or recklessly disregarded whether or not it was true. Also, if you analyze the case law of the European Court of Human Rights in Strasbourg, there are some of these theories which are reflected in the decisions of this court. For instance, in a landmark decision, Handyside versus the United Kingdom, the European Court of Human Rights defined the freedom of expression as one of the essential foundations of a democratic society, one of the basic conditions for the progress and for the development of every man. So you can clearly see the reflection of these theories in the case law of the relevant courts. However, we will not spend much, actually any more time on this, and we will switch to the context, to the online context, to the digital context, and try to understand how is the concept of speech being interpreted in online environment. Well, first of all, I would like to emphasize that the terminology in different legal acts in different jurisdictions is not at all harmonized. So if we take a look at certain sources in comparative law, we will instantly understand that at least two different terms are being used, either speech or expression. However, they are interpreted in a, let's say, similar manner. First, if we take a look at the US Constitution and the famous First Amendment, I will read this and you can also see it on the slide. Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So clearly you see that this source is referring to the concept of the freedom of speech. In the French Declaration of the Rights of Man and of the Citizen, we are identifying the term freedom to express thoughts and opinions. So as you can see on the slide, the free communication of thoughts and opinions is one of the most precious of the rights of abuses of this freedom and shall be defined by law. Going to some more recently adopted legal documents, we are starting seeing the term freedom of expression rather than the term freedom of speech. For example, the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, which are adopted in 1948 and 1966, respectively. They both state that individuals have a right to freedom of expression, and this right includes the freedom to seek, receive, and impart information and ideas of all kinds. Also, the European Convention on Human Rights employs the term freedom of expression. So today's topic, because this term includes not only something called direct speech, meaning words, it also includes something called symbolic speech, meaning actions. So in United States, the freedom of speech includes, among others, the right not to speak, the right to use certain fancy words and phrases to convey political messages, the right to advertise commercial products, the right to burn the flag in protest, for instance. And the European Court of Human Rights, which is more relevant for us in Europe, also considers that the freedom of expression covers both direct speech and symbolic speech. So, for instance, the court found that the freedom of expression includes artistic expression, such as a painting, or the production of a play, or information of a commercial nature. And with regard to this so-called negative right, the right not to express oneself, the European Court of Human Rights does not rule out that this right is protected under the convention, but it has found that this issue should be addressed on a case-by-case basis. So specifically in the context of the internet, the European Court of Human Rights emphasized that Article 10 of this convention, which refers to the freedom of expression, apply to communication on the internet, whatever the type is being conveyed and whatever message is being conveyed, and even in cases that the profit making. If we check the case law, we can, for instance, conclude that a simple like on a social network is being interpreted as a form of speech, because it represents kind of a statement of the internet user. And this is established in US law in the case Bland versus Roberts. And in this case, a public sector employee sued because he was fired for clicking on the like button on Facebook on the campaign website of his employer's re-election rival. And the judge dismissed the free speech claim, stating that liking web content is not sufficient speech to warrant constitutional protection. However, the Fourth Circuit reversed the case on the First Amendment issue, holding that on the most basic level, clicking on the like button literally causes to be published the statement that the user likes something, which is in itself a substantive statement. I'm reading now the part of this decision. In the context of a political campaign Facebook page, the meaning that the user approves of the candidacy whose page is being liked is unmistakable, according to the court. That a user may use a single mouse click to produce that message that he likes the page instead of typing the same message with several individual keystrokes is of no constitutional significance, concluded the US court. Actually, choosing to like something on Facebook produces speech in this sense. Also, the results which are produced by internet search engine, according to certain courts, may qualify for protection, and this has been established in the US case Search King versus Google technology. In this case, the court concluded that Google's ranking of pages were subjective results that constituted constitutionally protected opinion, entitled to full constitutional protection. In Langdon versus Google, the court refused to order Google and Microsoft to list plaintiff's site in their search results. And I will read you just a snippet from this court decision. So I'm quoting now: the First Amendment guarantees an individual the right to free speech, a term necessarily comprising the decision on both what to say and what not to say. The injunctive relief sought by plaintiff contravenes defendant's First Amendment rights. Going back to the beginning, if we try to compare the US and the European approach, we could see some differences. We could even qualify as methodological differences in the meaning, in the sense that the US law differentiates among several categories of speech, and some of these categories are given lesser protection or no protection under the First Amendment, such as obscenity, fighting words, defamation, child pornography, perjury, blackmail, incitement to imminent lawless action, true threats, solicitation to commit crimes, plagiarism of copyrighted material. On the other hand, the European approach consists in prescribing different limitations of freedom of speech. For instance, this includes the protection of children against materials that are harmful to their development, the protection of certain social groups against hatred, etc. The next issue I would like to address is whether social networks should be seen as a public forum or not. So initially, these social networks have been legally considered as private places. But in recent years, we are starting perceiving them as forums of public communication. This public forum doctrine is articulated in US case Perry Education Association versus Perry Local Educators Association. The court explained that there are actually three categories of government property for the purposes of access to expressive activities, and the government has different right to interfere with these different types of spaces. But let's put this decision, which is already 40 years old, apart and go back to something much more recent, which is also related to the issue of social networks as a public forum. As you know, the politicians are now using their accounts on social networks to communicate with the citizens. But what happens when the politician starts using his private account to communicate with the citizens while he's in office? And this is something which was addressed in the US case Knight First Amendment Institute versus Trump. So in this case, a group of 7 citizens, which were represented by the Knight First Amendment Institute, sued the American president at the time, Donald Trump. And their complaint alleged that when President Trump blocked them on Twitter, he engaged in viewpoint discrimination in a public forum. And this action violates the freedom of speech, which is guaranteed by the First Amendment. On the other hand, the President Trump argued that this Twitter account was his private account, that the account was created in 2009, and that it was not subject to the First Amendment claims at all. In 2019, the courts decided that the government use of social media creates a designated public forum, and that the government officials cannot engage in viewpoint discrimination by blocking comments. And there is a certain follow-up to this case, meaning in the sense that the petition for rehearing was denied on the 23rd March 2020. On the 31st July 2020, the Knight Institute filed a second lawsuit in federal court against President Trump for continuing to block followers from his Twitter account. And in April this year, so on 5th April 2021, the Supreme Court vacated the judgment because the case was being remanded to the United States Court of Appeal for the Second Circuit with instructions to dismiss the case as moot, given that Donald Trump is no longer American president, he's a private citizen now. So from a freedom of expression perspective, this is particularly relevant to determine whether social networks should be treated as tech companies or media companies. And social networks, such as Facebook, for instance, they insist repeatedly that their service is simply a neutral tech platform, that they're not a publisher or a media company. And the publisher could be expected to make some factual distinctions, some qualitative distinctions. A publisher might be responsible, even legally, for the content it publishes. But a platform is nothing but empty space. So this is their, let's say, defense. However, even social networks do not stick all the time to their defense, as we called it, that they are just tech companies. And I will give you an example in this respect. There was court proceedings in the United States when Facebook was sued by an app startup. And this app startup alleged that Mark Zuckerberg developed a malicious and fraudulent scheme to exploit users' personal data and to force rival companies out of business. Facebook lawyers argued that decisions about what not to publish should be protected because Facebook is a publisher. And Facebook lawyers argued in court that the social network's decisions about data access were actually a protected activity, because this includes both the decision of what to publish and the decision what not to publish. So to conclude, if social networks are publishers, then the manner in which they select the content results. This is a consequence of editorial decisions, and this should be treated as speech. But also, if a social network has an opinion, then such an opinion could, under certain legally defined conditions, be restricted. So if we take a look at the legal basis for content removal in comparative law, we can conclude that there are actually two sets of rules. There are, on the one hand, regulations adopted by the state, and there are some internal rules adopted by social networks themselves. And there are two prevailing legislative models in comparative law. One is the US model, the other is the EU model, but it is not just EU model, we could call it European model because it also includes the sources of the Council of Europe. And of course, the US model influences some other countries which are close trading partners of the United States. For instance, there is an influence of American law in NAFTA 2.0 agreement, which is concluded between Mexico, Canada, and United States. So let's briefly mention and analyze some of these sources in comparative law, sources which represent legal basis for content removal. In the American law, the most important source is the Communication Decency Act, which is adopted in 1996, and particularly the section 2030. You have certainly heard of this piece of legislation. So as you can see on the slide, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So there are actually three elements to this immunity. The first element is that the immunity applies to a provider or user of an interactive computer service. And the courts have interpreted providers extensively to include any service which is available through internet. This other term, users of interactive computer services, this should cover everyone who is a customer of a provider. The second element of this immunity is that it applies to any claims that treat the defendant as a publisher or a speaker. But if you analyze the case law, you can understand that the courts usually interpret this element more extensively. So it applies regardless of whether the claims elements contain the term publisher or speaker. And the third element of the immunity is that it applies when the plaintiff's claim is based on information which is provided by another information content provider. So basically, by a third party. This section 230 immunity is not unlimited. Of course, there are some exclusions, and there are 4 statutory exclusions where it is categorically unavailable. So first, prosecutions of federal crimes such as obscenity or sexual exploitation of children. Second, it does not apply to plaintiffs' claims which are based on the Electronic Communications Privacy Act. Then it does not apply to claims which are based on the Fight Online Sex Trafficking Act, FOSTA, and it does not apply to intellectual property claims. There is another piece of legislation which is known to those dealing with intellectual property law. This is, of course, the DMCA, Digital Millennium Copyright Act, which introduced a specific notice and takedown procedure. And this procedure is related to copyrighted works. So this procedure allows for a copyright owner to request the removal of content which is posted online. And this DMCA shields online service providers from monetary liability and limits some other forms of liability for copyright infringement in exchange for cooperating with copyright owners to remove the infringing content. We will now switch to the European Union. Since we are Europeans and this project is a European one, so I would like to dedicate the remaining time to the European approach, and you can read more on the US approach in a book which is going to be published as one of the project results. One of the most important pieces of EU legislation and with respect to content removal is certainly an EU directive on electronic commerce, which is inspired by the American Digital Millennium Copyright Act. But the European directive is, although inspired by US law, different to the DMCA model. First of all, the directive governs all claims which are related to user-generated content, not just copyright. And these claims may be derived from private law, for example, in the form of defamation, copyright infringement, also from criminal law, such as incitement to violence or hate speech. And the second distinction is that the notice and takedown mechanism, which is prescribed by this directive, allowed for a certain flexibility, meaning that this is a directive and not a regulation. So we have, as a result, 27 different harmonized but still not identical legal regimes in EU member states, and 28 if we count in the United Kingdom, which was part of the European Union at the moment when this directive was adopted and transposed into the national law. So what can be the problem here? Well, the problem can be that if there are this type of incitements to remove the content expeditiously, clearly you can make a mistake when doing so, and clearly you can abuse this procedure for censorship purposes. And for that reason, the Court of Justice of the European Union in case Pro Musicae clarified that in transposing the directives and implementing the transposing measures, the member states must take care to rely on an interpretation of the directives which allow a fair balance to be struck between the various fundamental rights protected by the community legal order. So basically the Court of Justice of the European Union introduced this fair balance doctrine, which was further explored in cases Delphi versus Estonia and MTE versus Hungary. I will not get into details on these cases because this is going to be the topic of the next webinar. But just as a remark here, it is good that this fair balance doctrine is introduced. However, I need to make a comment on this, that this doctrine is unclear at present. So we will see in which direction the case law is going to further develop. There is also a specific piece of legislation which is related to copyright only, and that is, of course, the famous directive on copyright in the digital single market, which is adopted in 2019. And it seems that this is actually a shift from a vertical approach because this introduces a specific regime which is related to copyright only, and there is another step which is being proposed here, meaning that we are switching from the system notice and takedown to the system notice and action. In what sense? Well, this directive requires the platforms to obtain authorization to communicate, to make available the content which is uploaded by the users. but it seems almost impossible to obtain authorization for entire content which is uploaded by the users. So they will actually have to rely on the second possibility, which is offered by the directive, which allows them to avoid liability if they meet a number of cumulative conditions. So they must demonstrate that they have made best efforts to obtain authorization, and that they have made best efforts to ensure the unavailability of specific works for which the right holders have provided them with the relevant and necessary information, and that they acted expeditiously subsequent to notice from right holders to take down the infringing content and made best efforts to prevent its future upload. So basically, these conditions are being criticized in legal theory, especially the second condition, because it appears to impose an upload filtering obligation. And the third condition, because this third condition seems to introduce the notice and takedown mechanism, which is prescribed already by the Directive on Electronic Commerce since 2000, but also a notice and stay down mechanism. And this notice and stay down can be also translated as a re-upload filtering obligation. So we will see in which manner the countries, the member states of the European Union will transpose the rules, and in which manner they will interpret these rules. So perhaps it is still early to make a final assessment. There are some other pieces of legislation in the European Union which are relevant to the content removal topic. There is a proposal for a regulation on preventing the dissemination of terrorist content online, which was published in 2018. And the same year, there is this latest review of the Audiovisual Media Services Directive. And this latest review of this directive is relevant for us because it defines a video sharing platform service in this manner. So this is a service where the principal purpose of the service is the essential functionality of the service is devoted to providing programs, user-generated videos, or both to the general public, for which the video sharing platform provider does not have editorial responsibility. Basically, the European Commission acknowledges that social media services became an important medium to access audiovisual content. Although this directive explicitly states that the safe harbor provisions of the Directive on Electronic Commerce remain applicable, it does require member states to ensure that video sharing platform providers operating within their jurisdiction take appropriate measures to protect minors from programs, user-generated videos, and audiovisual commercial communication, which may impair their physical, mental, or moral development. The general public from programs, user-generated videos, and audiovisual commercial communications containing incitement to violence or hatred, and the general public from programs, user-generated videos, and audiovisual commercial communications containing content, the dissemination of which constitutes an activity which is a criminal offense under European Union law. So what constitutes an appropriate measure is to be determined in light of the nature of the content in question, the harm it may cause, the characteristics of the category of persons to be protected, as well as the rights and legitimate interests at stake. So this is also something where we can make a similar comment. I see in the chat box section that there is a question which relates to the proposed Digital Services Act. Yes, there are some elements in this proposal, which was published by the European Commission in December 2020 in the Digital Services Act, which are related to content removal. So there is a specific due diligence obligations which apply to hosting services and to online platforms, and online platforms are actually defined as a subcategory of hosting services. So the platforms will be required to disclose to regulators how their algorithms work and how their decisions to remove content are taken, for example. So in that sense, yes, there are some provisions which are relevant for content removal as well. But since this is still not adopted, I will not spend any more time on this because we have very few time left, and I would like to address and to conclude with that the internal rules adopted by social networks, which are related to content moderation. So you're all users of at least one social network, and you're very well aware that there are some terms of services, community standards, privacy policies, IP policies, which are drafted, adopted by the social network themselves. And we can say that there is a clear transparency deficit because actually the social networks are drafting these rules themselves. The other remark we could make about this enforcement of internal rules on content moderation is that most of the time they're actually using some automatic detection software and automatic filtering technologies, and there is almost no human interference in that. And this bias can be introduced in various stages of this process, even in the design of the algorithm which is being used. And you're certainly aware of some clear mistakes which are made by social networks in moderating the content, or at least we can call it questionable decisions. For example, in 2016, Facebook blocked the sharing of the napalm girl photo. And this is a photo of a young Vietnamese girl which is running naked from a napalm attack on her village. And Facebook blocked the sharing of this photo under its child pornography policy. And after widespread criticism from different media experts, human rights organizations, news organizations across the world, Facebook reversed this decision. And I see that there is a question in the chat box which referred to the oversight board. This is an initiative undertaken by the Facebook CEO and founder. He published in 2018 that his company will create this independent governance and oversight committee. And in September 2019, the Facebook published the Oversight Board Charter. So this is a document which lays down this structural relationship between Facebook, between the Oversight Board, and between the trust. And the trust actually serves to ensure the financial independence of the board from Facebook. When you analyze the chart, you realize that the board has between 11 and 40 members. The number of members will increase as appropriate, as indicated. The members of the Oversight Board must possess a broad range of knowledge, competencies, diversity, experience at deliberating, etc. So the charter instructs the board to split into subsections, into let's call it team panels, when reviewing cases, and each panel has to contain at least one member from region where the case arises. if we analyze the provisions of the Charter related to the competence, well, this is not that simple. Excluding content that was removed in compliance with local laws, a request for review can be submitted to the board by either the original poster of the content or by a person who previously submitted the content to Facebook for review. So basically, the oversight board has the authority to review not only the content that is removed, but also the content that is kept up. Still, if we continue the analysis and switch to the analysis of the oversight board bylaws, there are many actually exceptions to the board scope of review. For instance, only single object removals of organic content posted on Facebook and Instagram are eligible for review. Let me just explain this. Well, first, when they say organic content, this is actually the content which is posted by users, contrary to commercial advertising. And when they say single object, it means that it is a post of a photo, of a video, or a status message. On the other hand, when they use the term complex object, it means a user profile or a group profile or a page. Also, content decisions which are pursuant to legal obligations, including those having to do with intellectual property, Facebook Marketplace, fundraisers, Facebook dating, messages, and spam, are at the moment out of the scope of the oversight board. So basically, it is a positive initiative, but still, we will have to wait and see in which direction this is going to develop. To conclude, since we are already over the scheduled time, I would like to say that we are now witnessing that the social networks are somewhere between their proclaimed neutrality and a reality which consists in value-based decisions. And we can identify two major downsides to this situation. The one would be the loss of equal access to speech, the loss of equal participation in speech on these platforms. And the other problem is the problem of accountability. And as we have seen in the case of the Facebook Oversight Board, this problem of accountability is being recognized by social networks themselves. So we have now reached the end of this webinar. Unfortunately, we only had 45 minutes. I would like to thank you for your attention and to let you know that I will be also holding another webinar in 6 months. Please check the website of the Ferenc Mádl Institute of Comparative Law in Budapest for the announcement of other webinars which will be organized within this project. And also by the end of this year, there will be a book and another publication which is going to result from this project. So all this will soon be available in written in much more detail. So thank you for your attention, and this webinar is going to be available at the YouTube channel of the Ferenc Mádl Institute of Comparative Law in Budapest. Thank you and goodbye.